position.
Certainly. I'm currently the Acting Chief Operations Officer for Business and Individual Taxes. Prior to that, I've been with the organization for 12 years. I've always held various leadership roles. So I started off as the General Manager responsible for performance analysis. I then moved on and I became the Group Executive responsible for customs operations. Subsequent to that, I became the Group Executive responsible for capacity management, and my permanent position is the Group Executive responsible for tax compliance and case selection. And then I've been acting as the Chief Officer for the past 7 months and continue to do so.
Mr. Murray, you've given us a written statement in which you say you felt duty-bound to come and testify after listening to the evidence over the past months. And perhaps you can tell us why you felt duty-bound.
So towards the latter part of September, I sat in 2 of the public hearings, and I was absolutely shocked and horrified what I heard. And on the basis also that the judge has on a few occasions requested leadership, and specifically EXCO members, to come forward and to provide insight. And I think that's the main reason why I came. I wanted to make sure that that is not the only narrative that comes through. I'm hoping to provide a different narrative, and that's the reason why I'm here today.
Well, go ahead.
Okay, so firstly, my testimony today would be, I'll be covering 2 broad areas. In specific, our staff, and in more general, the taxpayers. And the second area that I'd like to cover, I'd like to speak about leadership, and specifically leadership during the tenure that this Commission's time frame is. So from the 1st of April to the 1st of April 2014 to the 31st of March 2018. So unequivocally, I'd like to start off by saying that I would like to apologize unreservedly to our current staff and to the staff who have left the organization. I think as leadership, and specifically now that I am part of EXCO, we've done an injustice to our staff. As I said that I sat in the inquiry, and listening to Yusuf Danat give testimony moved me, both in horror and in shock. I've been pretty fortunate over the recent weeks to actually have engaged Yusuf and coming face to face with him again, for a very brief moment. I was able to feel the hurt that we put him through. And not only him, but his entire family for 15 months. And there are many others like Yusuf. Friday afternoon, I was sitting in the inquiry. And during recess, I bumped into Kamaran Mudli, who has also been suspended for 19 months, who was back at work recently. I'm absolutely horrified, and I use the word collective because I am part of the leadership team. I was not part of the leadership team during the time frame, or was not part of the EXCO team during the time frame of this Commission of Inquiry, but I am part of EXCO now. And therefore, some part of the blame I have to absorb, and I accept that. You see, we cannot move this organization forward without acknowledging our shortcomings in recent years and the pain we've caused our staff and the broader tax fraternity. In rebuilding SARS, all staff must be on board, and trust needs to be restored and not instructed. The thing about trust is that it takes a while to construct, but it can be broken in an instant or two. However, doing the right things and doing it consistently will go a long way in restoring trust. Secondly, the reason why I elected to step forward and present today is that I wanted to acknowledge that SARS has lost a number of great leaders and staff members with the requisite technical capabilities. We were indeed in denial, or frankly, did not understand the capabilities we lost when we perpetuated the narrative that we did not lose many skilled staff members. However, SARS still has a number of great leaders and staff members with the requisite both leadership and technical capabilities. Our challenge in recent years is that the available leaders and the technical competencies were dispersed throughout the organization, and in many cases grossly underutilized or downright marginalized. Case in point, the modernization of SARS in the past 4 years has grinded to a halt. And many of the resources, the capabilities, managers, and leaders remain in SARS. But the strategic direction and the required funding for execution was channeled into other events, such as international travels, litigation, consultants, bloated EXCO support staff, the refurbishment and rekitting of the second floor in Block A, unwarranted security upgrades, and the balance of available funds were returned to National Treasury as SARS could not spend the allocated funds. Now, I'm acutely aware that there's a narrative out there, and it continues to be perpetuated, that National Treasury has not given us sufficient funds. And I think that's only partly correct, because the reality is, during the past 4 years, a huge amount of funds that was allocated to modernize our systems we were not able to use, and therefore it was returned to National Treasury. So a part of the current shortfall in funding is a direct result of our inability to spend the allocated funds in the prior years. This is particularly sad, as we have heard that SARS requires 1 billion over the next 3 years to upgrade its IT infrastructure. I must at this juncture stress that whilst the strategic direction in any organization is not only the sole mandate of the executive team, as group executives and executives should feed into that process. It is not the latter that was our challenge in recent years. It is the strategic direction at an ExCo level that has created great inertia within SARS. In actual fact, group executives and executives were marginalized and excluded from strategic decision-making, which was contrary to the prior periods where ExCo periodically called extended ExCo meetings which included group executives. I recall having a meeting with the suspended Commissioner Moyani on a particular matter. And in that meeting, present was the GE in the office of the Commissioner, the suspended Commissioner, and I. After we concluded on the matter at hand, I asked the suspended Commissioner if I could speak to him on a private matter. The GE in the office of the Commissioner was excused. The private matter that I wanted to discuss with the Commissioner was my concerns around the trajectory SARS was following. At some point in the conversation, we spoke about what is wrong with SARS. And I vividly recall telling the Commissioner, or the suspended Commissioner, Commissioner, what is wrong with SARS is that all of your chief officers think exactly like you. And therefore, somebody is not thinking. You need to have a team with diverse views who can debate and synthesize on complex matters and reach consensus and ensure execution. I don't think the Commissioner particularly liked my frankness, because thereafter our relationship cooled off. You see, leadership is more than just a qualification. It includes cross-functional experience, emotional intelligence, cognitive ability, and character. And there I refer to moral qualities. As we have witnessed during the dismantling of SARS over the past 4 years, some traits of leadership were missing. Many of the ExCo members have been on board under the suspended Commissioner's stewardship for at least a year, and others longer. I am thus perplexed, surprised, when I hear I cannot be held accountable for what transpired as I did not know. The reality is that as an executive member, you have a fiduciary duty of care and skill, and you should have known or probed more deeply when you saw staff were being suspended left, right, and center, or asked to enforce irrational and unlawful instructions, or in possession of a list of people who needed to be removed and replaced by others. I, personally, since my appointment as an ExCo member, probed and challenged many established norms. These were contentious and uncomfortable matters, but required reviewing. They include chief officers flying business class on local flights. It is important to note that prior to the suspended commissioner joining SARS, all chief officers travelled economy class on local flights. I raised the concern that during this period of austerity, why are EXCO members and the suspended commissioner's direct reports travelling on business class when flying locally? We had a robust discussion on this matter, and the general view was that the policy allows us. This decision was rescinded and the policy was amended. It is important to note that whilst the policy allowed this, the system or the form you needed to complete allowed each chief officer to elect business or economy class. Some of us elected economy because it was the right thing to do, despite the policy directive. The second matter, draconian recruitment policy. I once again table this. Why do we as EXCO perpetuate the draconian recruitment policy? There was a general view that this needed to be amended. I will speak about this in detail later in my testimony. The third matter, the Enterprise Compliance Program, which has been well ventilated at this inquiry and in the media. I have asked, who takes accountability for the Enterprise Compliance Program, and by when will it be refreshed? This, to date, remains an enigma. Despite accountability being assigned, and I will continue to agitate on this matter. Now I'd like to pause there, because you see, as part of my permanent role as tax compliance and case selection, the compliance program, series.
I'm not finding anything for compliance.
I apologize. Let me turn this off. Sorry, Siri.
Siri is crazy.
It's forgotten.
Siri.
Technology is fantastic when it works. When it gets in your way, not that great. So the compliance program, 3 months prior to this program expiring, I personally presented at EXCO, stating that this program is coming to an end. This is a significant program and underpins our risk and our case selection within the organization. And therefore it is crucial that it be renewed. That was about 2 years and a few months ago.
Mr. Murray, can I ask you a question there?
Certainly.
We had evidence from Dr. Madavela and one of his staff members who had just resigned about the manipulation of compliance figures, and the Auditor General made an adverse finding in that regard. That was the period when it fell under your control. Were you aware that the figures were being manipulated?
No, I was not aware that the figures were manipulated. However, and we were in Parliament last week, and we were at pains trying to explain this as well. You see, compliance is specifically around CIT, where the contentious or the allegation resides. So, and it could be 2 years ago, don't quote me at it, so about 2 years ago, because our CIT register is inaccurate. Today, we have 5.5 million corporates on our CIT register. CIPC, who is the master, so that's the Companies and Intellectual Property Commission, who is the master, has 2 million records only. So it's a clear indication that our CIT register is not accurate. What we then consciously done, for 2 reasons. One is to make sure that our resources are directed at activities that we know will firstly improve compliance and secondly healed. We then developed a framework which we called economically active. So we took the register and we said that there, and my colleagues in the room, he will know exactly the stats, but I think we say that they're going back, if you've transacted with this in the last 8 years, okay, and you have, and there were 22 discrete criteria that we had. So if you transacted us in the last 8 years, if you've had any assets, irrespective of whether you've communicated with us, but if you have assets, we'll never ever move you. If you have debt, so there were 22 criteria, and therefore we came up with the economically active. And that reduced our active register to about 1 million. Okay? Now, again, any prudent tax authority needs to make sure that they direct their limited resources at the activities that's going to give you the greatest yield. We believed then, and I still believe now, that that was the right thing to do. And we've disclosed this in the annual report. So what we actually done, my colleague, in the annual report, we had the full register, and then we had the economically active. So categoric to your answer, no. On that particular instant, the numbers were not manipulated.
So in which instance were the numbers manipulated?
And the annual report, I am unsure. You see, the one thing about SARS is that we are a data-driven organization, and everything is traceable. So it becomes very challenging to try and manipulate, because when Peter pulls numbers from a system and I pull numbers, the numbers must tie up. If the numbers don't tie up, you need to account as to why they don't tie up. So with the annual report, to the best of my knowledge, there's been absolutely no manipulation.
So are you suggesting that Dr. Malavela and Ms. Singh's testimony was incorrect?
I'm suggesting that they perhaps did not understand the difference between economically active and the full register. That's my suggestion.
Okay, I don't think it's worth a debate here, but perhaps you can give us that view in writing so that we can weigh it against what we've heard.
Certainly. So the fourth and final point that I brought up was protectors assigned to chief officers. Why do most chief officers and certain staff members have protectors assigned to them? This matter was robustly discussed, and I'm reliably led to believe that this policy is currently under review. You see, this is what responsible leadership does. It is their fiduciary duty to challenge matters they feel uncomfortable with, and one's moral compass that prevents them from wasting taxpayers' money by traveling business class on local flights. Now, before I get accused of flying business class in the past or in the future, when the public see me sitting in business class, let me hasten to say, on occasion, I have been upgraded from economy to business class, with no additional cost to the taxpayer or SARS. And this is normal practice with most airlines. Leadership must leadership must ask difficult questions so that there is absolute alignment and challenge the status quo, not merely going with the flow to appease your boss or your colleagues. Now, more than ever, SARS needs strong leadership, not individual leaders who are only consumed with their narrow divisional mandate or protecting their turf. Leadership that is able to transform or refine the enterprise mandate and ensure that a coherent strategy, the machinery, and capabilities are in place that will enable execution and the attainment of strategic outcomes. I believe that fixing SARS starts with appointing a commissioner that is apolitical. Furthermore, the new commissioner should not undervalue the institutional knowledge and experience vested in many of the existing SARS leaders when he or she appoints his or her executive team. It is my view that this has contributed to the unwinding of SARS. When SARS was gut of its experienced executive management team and replaced with a brand new team that did not understand the business or felt the urgency to expedite the learning curve. The fact is that SARS had and still has capable leaders within SARS to absorb any leadership role. I do, however, believe that a reasonable balance between old and new resources or capabilities is required in any progressive organization. I am sincerely hoping that the South African public does not lose hope in SARS, especially after last week's debacle, and as a result of us losing our way in the past 4 years. SARS still has a depth of leaders and technical capabilities that need to be better structured and deployed in rebuilding this once august organization. The rebuilding has commenced under Acting Commissioner Kingon. Our self-inflicted and marginalizing ways must stop, and we must start restoring trust and positive hope across all staff within SARS and across all stakeholders. The reason I emphasize all staff, this was another own goal, which I will get back to later. I embrace the Employment Equity Act and fully support the SARS transformational agenda. My permanent unit, tax compliance and case selections, black representation is currently at 81% compliance, which exceeds the SARS annual employment equity plan target of 79%. This positive compliance is emulated at leadership level and females in management. And therefore, I cannot be accused of being anti-employment equity. However, the own goal I alluded to earlier relates to the implementation of Employment Equity Act within SARS since the appointment of the suspended commissioner. A memo was approved on the 5th of July 2016, which gave effect to the practice in which certain designated groups, mostly African employees, were ring-fenced for vacant positions within SARS. The memo further stated that no deviations will be allowed on the basis of race, and in exceptional circumstances, deviation on gender will be considered. The authority was given to the Employment Equity Subunit, residing under the Employment Relations Unit, to gatekeep this decree. During the recruitment process, this rule was strictly enforced. And in many cases, Indian, colored, and white employees were not shortlisted, although they met the minimum requirements for the job, as well as being recognized as capable resources. It is my assertion that this filter should be applied at the final selection stage and not upfront during shortlisting. This has resulted in internal grievances as well as disgruntled employees who felt that the exclusion from SARS's recruitment process left them with limited career opportunities and advancements, which significantly impact their level of engagement and commitment. And I think this was well borne out in the recent Connection survey. Any deviation at interview stage had to be approved as an exception by the Employment Equity Unit as a deviation. Sadly, this practice remains in force today. Despite EXCO taking a decision a few months ago to correct this practice, and this speaks directly to the point that many staff members have highlighted at this commission, that it will be difficult to change this organization with the same people in place that has caused or contributed to the organization's downfall. As there will be reluctance to effect change to policies that you have policed. The way employment equity targets were enforced at pre-interview, shortlisting phase resulted in excluding certain groups that actually met all job requirements at the shortlisting stage is surely not aligned with good practice. This decree was supported by the Human Capital Development Division and signed off by the suspended commissioner and enforced by the Employment Relations Unit within Human Capital and Development Division. The world of tax and customs is evolving, and the complexities associated with new and creative schemes are also evolving. And it is thus crucial that a progressive tax authority remains at the forefront of these emerging trends and capacitate accordingly. Here I specifically refer to transfer pricing and illicit trade skill set, where we were trying to attract but were constrained by rigid recruitment requirements. Within SARS, we were looking to attract the best capabilities, and yet we were placing onerous requirements to a small national transfer pricing specialist population, which is highly marketable and fluid. Many of our competent transfer pricing staff members were poached by outside, mainly financial and legal firms, and we were battling to fill these vacancies. I recall a colleague of mine, a group executive who will remain nameless, lamenting this fact in a quarter revenue steering committee meeting in which EXCO members were present, including the suspended commissioner. The colleague tried on 3 different occasions to recruit transfer pricing specialists without success and applied that the EE requirement be waived for these scarce and valuable resources. Now I'd like to pause there because I'd like you to understand how long it takes to actually get an ad out within SARS and to do an advertisement and the whole process. It could take easy up to about 2 to 3 months after you've received all of the myriad signatures. The colleague has tried on 3 occasions. 3 different ads were put out and she was unsuccessful. The colleague was lamented from a dizzy height A very senior human capital development staff went off at the colleague, and I am paraphrasing, that we are undermining blacks. You are telling me you cannot find capable Africans. You will not get this deviation. A number of EXCO members sat through this rant without saying a word. A number of our staff are complicit in the unraveling of SARS, and they have a case to answer to. I am unsure why they have not yet been suspended. You see, being suspended does not mean that you are guilty. It does, however, imply that based on various allegations and testimonies, there is a case that you need to answer to. On Friday afternoon, as I was leaving office, I bumped into a well-respected and talented executive. Now, just to explain how the structures or the positions within SARS. So you would have a senior manager, then you'd have an executive, and then you'd have a group executive, the chief, and then you would have the commissioner. So he was an executive, and we were engaging on the commission and the last week's media coverage that SARS was exposed to. His overall view was, and I paraphrase, there is far too much talking and covering tracks without any personal accountability, consequences being absorbed by wrongdoers. Close quote. I must say, I support his view. However, remain hopeful that both the Commission and the Acting Commissioner, under their different mandates, will address the wrongdoers and ensure that the appropriate sanction is levied. As an EXCO member, I too will continue to be vocal on highlighting key individuals I believe were complicit in the unwinding of SARS. I've already done so to the Acting Commissioner and will continue to do so. To be quite frank, if I was an EXCO member during the suspended commissioner's tenure, I would proactively approach the acting commissioner and request him to suspend me, as this is the right thing to do in my opinion, in ensuring that the healing and reconstruction of SARS is expedited. Once the case against me is concluded and I am found not guilty, I will then return with my head held up high and contribute without a cloud over me in the rebuilding of this once august organization. I do believe that it's not yet too late to do the right thing. Our singular focus should be on restoring our staff's lives and their trust in SARS again, building stakeholder relationships, and contribute towards building this once proud organization. We need to reignite the higher purpose. And it starts with ethical leadership. Leadership that has their staff, the tax fraternity, and the broader South African at the core of their decision-making process. Advocate.
I just have one question. We've heard a lot of disquieting evidence about the risk engine and the manner in which it's calibrated, and the lack of congruence between what the risk engine spits out as problematic and the capacity of staff to deal with it. What are your views on that?
So I think before I speak about the risk engine specifically, if you allow me, I'd like to, because there is this misnomer in SARS that, or not in SARS, and it's being perpetuated externally, that the only compliance intervention that we have is a risk engine. Okay? So you see, compliance, there are a number of compliance interventions within SARS. The risk engine is just one of them. But we also have detailed profiling, we have criminal investigation, and that gives form of the entire risk landscape and the execution machinery that we have in place. Now, with regards to the risk engine specifically, firstly, since the inception of the risk engine, and let's just restrict it to PIT currently, we've grown the yield associated with fraud from round about 1 billion to last year, we prevented 9.5 billion rand for fraudulent activities being processed. Okay? The risk engine is always calibrated with capacity. We work very closely, and the only unit predominantly that is involved with the execution of risk engine alerts is compliance. So every year, we understand exactly how many resources they have, what their requirement is, and we try and calibrate as closely as possible. However, there are exceptions. When during filing season we discover fraud, we throw capacity out of the window. We will immediately stop all fraud. So last year, there was huge fraud associated with banking details. And these are banking details that are not FICA required. So you go to PIP, you can open up a banking details, and we found huge fraud in that regard. When we found that, we immediately clamped down, and we therefore tweaked the risk engine to say that any banking details that was changed during the last financial year, you will stop. Okay? Now that was a conscious leadership decision that we took. What the team then done is that the team works 24 hours to try and mitigate. So the first thing is containing the outflow, the loss to the fiscus. Thereafter, the team then tries to understand exactly how can we refine the rule, because the rule that we implemented was a very blunt one. So how do we refine the rule? And then we discovered, well, this is actually a very specific bank set, and that's why we knew that this related to non-FICA'd ones. Okay? Once they've done that, we then amend the rule to be very specific, and then we will go back and we will auto-release. So we'll stop whatever it is, 100,000 of them. Once the rule has been amended, we will then backflush the 100,000 through the new rule. And 95% of it then gets released. But our number one priority when we are confronted with fraud, we are less interested about capacity at that stage. It's about preventing the loss to the fiscus.
I understand that, but we've seen as a matter of fact that people who are obviously wealthy in this society end up paying very little tax. And compliant taxpayers get audited again and again and again, or at least stopped again and again and again. How do you reconcile those two facts?
So again, and we're speaking risk engine, so I'm going to elaborate on the risk engine. You see, the only time that you'll be alerted on the risk engine is based on what you declare. So if you don't declare and you don't have a return, obviously the risk engine won't alert you. We have other initiatives that we'll pursue with regards to that. Secondly, the basis is that what you've submitted, is correct. But we have a whole lot of different models that we do. So if you're in a certain salary bracket, we will run that relative to a population that's similar to yours, and if you're anomalous, you'll be alerted. So there's a whole lot, and I think at last count, we had about 169 different risk parameters that we apply in the risk engine.
Suppose I'm asking you, do you think they're appropriate and they're working properly?
So again, and it's the understanding of the risk engine, and I've been at pains to try and make sure that most people understand.
I'd like you to answer my question. Do you think the risk engine is appropriate and working properly?
I think the risk engine is appropriate. I think the risk engine is working properly, but the risk engine needs to be continuously tweaked, and that's what the team does. We have a team that continuously looks at it. When they find fraud, they will then implement a rule set to be able to mitigate that. So yes, I do believe that it's appropriate. I do believe that it's working properly.
So the complaints we get about compliant taxpayers being audited again and again, are you aware of that? Is that part of what you think is appropriate?
I'm absolutely aware of that. And this year specifically, we have implemented, again, as I say, this is an iterative process. So each year, firstly, we try and reduce the number of alerts. Okay? So this year, I think we're going to alert 100,000 fewer taxpayers, because we understand that we do stop taxpayers sometimes for the same. So this year, you'll be stopped for medical aid. Next year, you'll be stopped for medical aid as well. Okay, so we're continuously finding it. And we've just had EXCO approval for next year that we're going to revolutionize the way we do filing season. Because we're probably going to stop about 50% less alerts based on materiality. So again, pointedly to your question, this is an iterative process, okay? But we're at the stage now where we're going to take a quantum step forward and make sure that we minimize the alerts with repetitive alerts.
Well, I think that's important, that there is an iterative, but we have, there is a wide-held perception that whether you're a compliant or a non-compliant taxpayer, you get treated the same. And there's no incentive to comply. So I suppose I'm confused as to what you're saying, that you need to change the risk engine, but you're also satisfied with the risk engine.
So what I am saying is that the risk engine is an iterative, and not only in SARS, but throughout the world with all tax authorities. You need to continuously, fraud is ever moving. So today we'll mitigate something, tomorrow there's a full-time team out there that work to try and penetrate your risk engine. So what I am saying is that the rules that we have we believe that they are sound. However, the rules need to continuously be evaluated. But the step change that I'm speaking about, where you are right, and I totally agree with you, there are times where we stop taxpayers for the same thing, and I'm one of those taxpayers. So without fail, every year I get alerted. I have rental property. Now, rental property is high risk, okay? But not everybody in the category of rental property is submitting fraudulent returns, okay? So we're acutely aware of that, and that's why we're saying that we've now taken, and a lot of what we're discussing and implementing, it's not new. We've always wanted to do this, but there was just no appetite to do it. Okay. Now that there is an appetite, and I can't recall in SARS, filing season, we're speaking about filing season 2019, where the plan has been signed off. It's unheard of in SARS in the last 4 years.
Can I just ask you about a question that was raised there? And for the moment, you can just help me on technical issues. We'll come on to broader issues in a moment. The question that was asked concerned taxpayers who are apparently very wealthy, but who pay very little tax. Now, as you say, your risk engine doesn't pick that up at all. Is there any capacity here at all that is looking at apparent capital coming from nowhere?
So, Judge, yes, there is. And that's the second leg, the leg around profiling and really going into a taxpayer's affair in detail. And the one that I'd like to make reference to is that...
Well, don't talk about taxpayers, if you don't mind. Don't mention taxpayers.
No, I won't mention names. No, absolutely not. So the scenario I'd like to make reference to is that we have a compliance system, and it's a direct interface with National Treasury. And we now have all of the data associated with tenders that National Treasury pays. So we have superimposed that data with compliance. Okay? So firstly, we're seeing that everybody that received huge tenders, are you on the tax register? If you are on the tax register, are you actually compliant and paying? And we have, and again, my colleague is here, he'll be more detailed on this. At last look, we had about 20 to 30 cases on the tender alone with non-compliance that we have triggered. So yes, we definitely look at it, but I think you also need to understand that, when you speak about the risk engine, you are speaking about millions. Last year, we probably alerted across tax types, I would say probably about 2.2 million returns. when you are speaking about profiling, we can only do 10,000 cases, and that's cut across all tax types, okay? So the capacity is very restricted because of the nature of a profile and the execution that happens thereafter. It's very detailed. It cuts across taxes. It cuts across periods. It could take up to 3 to 6 months to actually conclude one of these. So to your answer specifically, yes, we are. Can we do more? Absolutely.
Well, you know, you're talking again, when you talk about matching treasury figures with whatever, that's a matching of figures. Really, it's what your risk engine does to a large degree. I'm talking about, is there not someone who uses the human mind? Because we have, if you say, yes, we have that capacity, I would like to know why it's not being used, because we have seen the tax affairs of a number of taxpayers. And it's perfectly clear that it passes through the system simply because the minimal income tax that is paid by a person year after year doesn't get picked up by the risk engine for obvious reasons, that it's always consistent. But if you look at lifestyle, a reputed lifestyle, an apparent lifestyle of some of those taxpayers, they bear no relationship to the income tax they pay. So and this has been going on for years, and there's no sign at all of anyone looking at that. That's why I'm asking you about, is there no one who is not merely matching figures, but sitting back and say, I better look at that taxpayer's affairs. And we've seen in one company, it was produced for me, was a spider's web of related companies, bank accounts and everything. I must put it up on my wall at the end of this as a bit of graphic art. It would take a long time to investigate that, but it is worth investigating. But we've seen no sign of that occurring. Let me just add another one. Huge VAT refunds are paid. They're paid out on the basis of documents. Well, a lot of those VAT returns, VAT repayments, you'd expect the documents not to be genuine. And yet they're simply paid out because all the documents are there. That's what concerns me, is that kind of thing which requires human intervention, not just mechanical intervention. And it doesn't seem to me there's anyone doing that. Would that be correct?
No, Judge, I don't think that is correct. So we definitely have capacity and capability, and I'm acutely aware where we do what we call asset reconstruction of individuals.
Yes.
Okay, and there's a number of those cases going. So we have a number of them in the pipeline, goes through the audit facility. So, but again, I reiterate that so if you're looking at personal income tax or individuals, of the 10,000 that we do annually, I think PIT, we do less than about 800. So there's 800 of them that we can only do. So yes, there might be some that we have not done, okay, and I'm not saying that the only reason we haven't done it is as a result of capacity, but that is one of the reasons. So we have limited capacity. These are in-depth cases. They span multiple years, okay, but we definitely have the capacity. Do we need more? Absolutely.
Is this capacity in the auditing field?
In auditing, that's right. So this is your
auditors.
Your auditors.
Now, I'm also told, and tell me if this is accurate, that the KPIs of the auditors are weighted towards the number you get through. So it's very easy to pick up my tax return, phone me, take 10 minutes for me to give my documents, and there's one down for the day. And is that correct, that the KPIs are weighted towards numbers rather than substance?
So again, Judge, when we speak about audit, you have compliance audit, that is your numbers.
Yes.
Okay. Then you have investigative audit, that is more intense.
Yes.
This one here, on the left-hand side, it spans multiple months to do. So this is not weighted around numbers. On the right-hand side...
you haven't understood the question. The KPIs, in other words, what you need to achieve in order to get your bonus, is it weighted towards numbers or weighted towards substance?
Yeah, so that's what I'm trying to explain, Judge. I'm saying, firstly, in audit, there are two different audits that take place. The one is definitely weighted towards numbers.
Is that the verification?
That's the verification, here. Because remember, the risk engine is very specific. The risk engine says that I'm alerting you for medical aid, so it's 1 year one risk alert, and that's where the auditor needs to then hone into. The risk engine then also automatically generates a letter and sends it out. Only when that information comes back, okay, then the taxpayer or the auditor needs to then, the compliance auditor needs to have a look at that. But I think your point is correct, that contributes towards
Sorry, Mr. Murray, I'm not sure you're really dealing with my question. Just confine it to my question. And I'm not talking about document verification.
Okay, yes.
I'm talking about substantive audits. Are the KPIs of the auditors weighted towards numbers in that field, or are they weighted towards substance in that field?
I think they definitely weighted towards substance. Again, that's my perception of it. Audit is not an area that reports into me, but I work quite closely with them, and the mere fact that it takes anything from 3 months to 6 months to complete an audit, I think it leans towards substance and less so numbers.
Do you know what the KPIs are of those auditors?
No, what I do know is that...
That must be in a document of some kind.
Yeah, so the group executive or the chief officer responsible for enforcement will have all of that
Okay, that's
available.
all I needed to know. Thank you.
Sorry, Judge, can I just follow? The judge asked you queries whether there is human intervention. Can I ask you the converse of that? What stops human intervention operating adversely to the fiscus?
Do you mind rephrasing that question for me?
Can there be human intervention that assists a taxpayer against the fiscus?
In other words, that says I won't look at that case for audit, rather than that I will.
Sure.
Or having looked at it, I'll let it through.
Sure.
What checks and balances are there on that?
So firstly, the reality is that we are speaking about individuals, okay? And it's possible that individuals can overlook something. But on the audit space specifically, and again, you're asking me an area that's not my area of expertise. But
all I'm asking, is there any systemic mechanism
Yes.
to prevent that?
Yes. So there is. So again, on the audit side is that, there's a number of sign-offs. So a case goes through different steps, and at each step it needs to be signed off by either a specialist or a senior person. So there are handoffs and sign-offs in that regard, and that should mitigate some of it.
Are you finished? No, sorry.
Just want to go back, Mr. Murray, to your meeting, the private meeting you had with the commissioner. Just if you could just help me just recall, at what position were you at that time?
I was the group executive responsible for tax compliance and case selection.
Yes. And what was his reaction to the submission that you had made around his team thinking exactly the same way as he did, and therefore no one able to provide any diversity of thought?
He did not respond.
Mr. Murray, the question that the judge posed about, people who do your in-depth risk profiling and who are able to map up, and just make a link between the wealthy people and their assets and the income, so that SARS can end up collecting what it needs to collect. Is that the type of work which was done by those specialized investigative units which were disbanded by SARS?
So we have, and I know you want yes or no, but I can't give you a yes or no answer. So we have profilers that actually, in case selection, we have profilers that do detailed risk assessment, and they will generate the profile. So no, that is still in place. However, the unit that was disbanded also had very specific capabilities and would go after niche taxpayers or industries, and that, again, that's an area that I'm not close to, but we've heard that there's very few cases coming from there currently. Okay, and I think I'm being generous when I'm saying very few cases coming from that aspect of it. But with regards to profiling, that is happening. If anything, over the last 3 years, we've actually increased our capacity around profiling.
Mr. Murray, sorry, did you want to ask him?
Just to say, Mr. Murray, we have a number of affidavits that speak to the issue of the KPIs. They are based on numbers. There's no question about that. And that's why I put to you that there is a mismatch between what the risk engine is demanding and what investigative auditors are capable of doing. We have affidavits testifying to the enormous stress that those people are under. Now, I think it's something that has to be looked at.
But I think that's the problem, in the statement that you articulated there. The risk engine will never ever generate an investigative case.
Yeah.
Okay. So the risk engine is purely for compliance. It's high volume, it churns, and it takes.
Let me say case selection. The whole process of case selection, and then the people available and their KPIs, there seems to be a mismatch.
I think in any organization, when you have two different units, one that creates cases and the other one that executes, there's always going to be constructive tension. And I think that tension we need to encourage. So I, on a monthly basis, get a report in terms of each region, how many cases, just in terms of numbers, because we sit with enforcement at the beginning of the year, and we understand exactly what their capacity is. And the team is to make sure that they actually then provide them with that capacity. And as I say, that there's always constructive tension in that regard. So some regions might not have enough, some have a little bit over, but the case selection team will always strive to ensure that they balance that.
I would suggest it's destructive tension at the moment.
Anyway, you'll look at that, will you? You're now
Certainly.
in your charge of bait. Can I just go back to some broader issues you raised? The first one relates to transgressions and disciplinary proceedings. My impression is, and we've heard some evidence on this, that it's open to abuse in the sense that people can be targeted. In other words, you dredge up things from the past every time you want to target someone. And it seems to happen here from time to time that things get dredged up when necessary. Is that your experience as well?
Judge, that's definitely my experience, and I think it was well ventilated with various examples at the Commission.
Now, the question that I ask you is, because believe it or not, this Commission is really concerned with going forward. But is there a case to be made for some type of audit process before before disciplinary proceedings are commenced against people, so that you don't have it in the hands of one or a few people to decide who should be, against whom proceedings should be brought?
So, Judge, if the process works well, there should be no issues. The challenge is, and it happened with me, so when one of my staff members were investigated for multiple months, I didn't know anything about it. When they were about to suspend the member, they came to see me. And I said, I refuse to get involved with this. You want to engage me now that you want to suspend the member? Why didn't you engage me up front? So again, if the process works according to the way it should, so if you want to investigate somebody's direct report, you need to engage the person. There needs to be formal charges laid against the person.
No, but like you can lodge formal charges against people. You can drag something up from 5 years ago, 10 years ago, and lodge formal charges. You can go through the formal process. But I mean, the problem still is dredging up things to pursue people on. That's the problem. Now, that's a matter of judgment. It's not a matter of process, as it were. Is there a case to be made for some type of oversight of that? Some audit process before these things are started to avoid what has been happening?
Absolutely, and especially in lieu of what has happened over the last few years. Absolutely and categorically, yes.
Can I come to another issue, and that is EXCO? Is there a case to be made for a formal EXCO rather than just an informal EXCO, so that it can't simply be disbanded at will?
So my view again, I think there's definitely a case for a formal EXCO. EXCO is the advisory body to the Commissioner, So you need to have an EXCO. And most well-functioning organizations have an EXCO. Okay? But I think the core there is a well-functioning EXCO.
I understand that. You can have a well-functioning EXCO and you can have a commissioner that disbands it, as we've seen. The question I'm asking is, isn't there a case for a formal EXCO that legislatively provided for so that it can't summarily be disbanded?
Yeah. So, Judge, I'm not one for putting on too much red tape, and we've really been exposed to too much red tape. You know, you allude to one example. We've had multiple commissioners prior to that where it never ever happened. So one example does not constitute to... So my view, again, and this is my humble view, that, you know, a formal EXCO, that reports to the commissioner, and the commissioner needs to be held accountable. So the commissioner needs to be accountable to someone before he actually disbands an EXCO.
So you don't support the idea of a legislatively established EXCO? You see, the problem is that I think we're finding, not only here but elsewhere in society here, that perhaps the procedures are not robust enough to withstand attack. You understand what I'm saying?
Yeah.
You know, one might put in place systems on the assumption that everyone's being honest and is on the same route. But we're finding, I think, in various aspects of our society that they're vulnerable to attack. And that's why I'm asking about that. Should one not strengthen that? You say no, not really.
I'm always for strengthening, Judge. I'm just, in my mind, I'm just not clear what would a legislative mandate, what additional impetus would it give to having an EXCO in place that reports to the commissioner, like in the past, that functions quite well.
Yes.
That's the haziness in my mind.
And then you talk about apolitical appointment of a commissioner. I'm sure you're correct. Especially in a revenue authority, there ought not to be political swirlings. And I'm getting the impression increasingly as we go along that there are lots of political swirlings going on. How would you suggest a commissioner be appointed in order not to be politically motivated in any way?
So I think there were a number of suggestions made. One, a panel of reputable experts. So that's one suggestion. The other one is that the finance minister, I always have a challenge, specifically the commissioner, which is such an important function, where you have one individual only appointing him. So my view is, and again this is my view, is that you should have a reputable, diverse panel appointing the commissioner. Who that panel is, I'm less interested, as long as they have the requisite capabilities, they understand the business, but not only the business, they have broader leadership experience, they have, so it must be a diverse panel that appoints the commissioner.
And what do you say about the proposal that there should be an Inspector General who is sitting here on the side, at least it's like a car guard? He may not be able to intervene when the person steals the car, but he can at least tell someone.
So you see, I thought, and again I can be wrong, but I thought that and now that I'm actually thinking of my mind, that thought is incorrect, but I'll continue with it.
Well, if you haven't thought about it, I'd rather not have thoughts given sort of off the cuff.
I haven't thought about it then.
Okay, thank you very much.
Sorry, could I just ask one? You made a passionate statement about how this continued, this malfunctioning for a long time. What is your analysis why it didn't stop, why no one challenged it? Yeah. Systemically it continued.
I think it would be unfair to say that no one challenged it. So a number of us had, aired our views and dissatisfaction. But, when something is moving at speed and moving with absolute authority, it becomes very difficult to stand in its way because it will take you out.
Sorry, when it's crashing at speed.
Now, when it's moving with speed.
I'm repeating, crashing at speed.
Crashing with speed as well.
No one in the way says anything constructive to stop it.
Well, I think you added over there, they'll take you out. Is that what you said? Or didn't you say that?
I did say that. I did say that. When it moves at so much speed, it will take you out. And I think many folks, including myself, we try to influence where we could, okay? But similar to a few people that stood up here and said that, I too have a family, okay? And as selfish as it might sound, okay, I wanted to make sure that I'm not one of the individuals that's taken out. So where I could influence, I did.
There is an old saying that for evil to flourish, all that is required is good people to not to stand up. The problem with that is that it's said by people who are not in the position. When you're in the position, it might be more difficult. But anyway, you also said, the commissioner made an unconditional apology to people who had been damaged in the process. And I think implied in that is we don't want that to continue, of damaging people.
100%.
And I think you repeated that. You said as a senior leader you support that.
Absolutely, and categorically.
You don't want people to continue being damaged in order to go forward. Is that your view?
Absolutely and categorically. Yes, it is, Judge.
There's
been enough hurt.
Do you think there is a view in SARS that people ought to continue to be damaged? A view within SARS anyway?
Judge, if there is a view, that is no longer the dominant view.
Is there anything?
Is it not the dominant view on EXCO?
Advocates, I have great difficulty, whilst I am an EXCO member, speaking on behalf of EXCO.
Anything, Boyd?
Nothing, thanks.
Bobby?
I'm not sure if you'll be in a position to answer the question, but I should ask. Why do you think the people are still fearful? There's still this mistrust at SARS long after, we don't know where it came from, but why does it continue? And what are you doing as an EXCO member to bring that to an end?
So I think why it continues, for one, is that we have a commissioner still in place, although he's suspended. Secondly, many employees know that his henchmen are still around. Okay?
What do you mean about henchmen?
The team members that has executed his instructions, they're still around. Okay? And therefore that fear is still there.
Did you read, I'm not sure if you noticed a press media release that was put out by the existing commissioner through the mouth of his attorney somewhat recently. The journalists seemed to be a bit confused as to why there was a media statement. Did you see that media statement?
I could have, I'm not sure what it said, but...
Well, the last paragraph, let me quote it for you, perhaps not exactly. People concerned better be warned that in South African law, an employee, even if he's guilty, may be put back into his position purely on procedural grounds.
100%.
It seemed to be a very ominous warning. No one seemed to pick that up. Anyway, So I think that that's what you're saying, that
Absolutely.
people would, there's reason for people to remain afraid. I said in an interim report that this place is racked with fear. Do you agree with that?
Absolutely.
I said it's racked with intrigue. Do you agree with that?
Absolutely.
Thank you.
Thank you very much, Mr. Murray.
Thank you.
Thank you very much, Mr. Murray. It's been very constructive. Thank you very much.
Pleasure, Judge.
Yes.
Now we call Mr. Mapakela.
Mr. Mapakela is represented by counsel, and I think we should hear what counsel wishes to say. Yes, good morning.
Good morning. Thank you very much, Chairperson of the Commission and other commissions. And thank you very much for giving us the audience. The reason why we're here is because of the directive that was issued by the Commission to Mr. Mapakela, dated the 5th of October, calling upon him to come to the Commission to give evidence. There's been an interaction thereafter between Mr. Mapakela and his law firm and the Commission on what aspects does the Commission want him to testify about. A letter was sent to Mr. Mashiane spelling out 3 issues which were already contained in the directive which accompanied the letter about the issues that the Commission wants Mapakela to provide clarity on. Whilst the directive did not make any provision for Mr. Mapakela to clarify the Commission by way of an affidavit, and we don't know the reason why. Maybe we'll be told the reason. But our view was that given the fact that Mr. Mapakela has cooperated fully with the Commission from as way back as June, albeit in an informal way, and from around July on a more formal way, the correspondence that emanated between him and the presiding commissioner was really an indication that the Commission was satisfied with the manner in which Mr. Mapakela was cooperating with it. So, after the directive identified the 3 matters that the Commission wanted him to provide clarity, he took it upon himself that these are matters that he can clarify to the Commission by way of an affidavit. And he provided an affidavit dealing with the 3 matters identified in the directive. On Friday, there were further 2 matters that were raised by the Commission, which he also dealt with by way of supplementary affidavit. Our view is that Mr. Mapakela is an officer of the court and is a practitioner, could simply have been requested to provide an affidavit, and only if the Commission is not satisfied with the manner in which it has dealt with matters in the affidavit, would it put more questions to him. So we see no need then for Mr. Mapakela as a practitioner to be subjected to examination orally and to answer questions from the Commission orally. We have taken the liberty to peruse the Commission's Act and as well as the regulations that were promulgated by the President when setting up this commission, particularly the regulation that the Commission invoked in respect of Mr. Mapakela 11.3, 11.6, which gives the Commission or the Commissioner a discretion. It does not oblige the Commission to call a person to provide evidence orally and to be examined, but it exercises a discretion to direct a person to submit an affidavit, unless if the Commission has formulated a view that an affidavit will serve no purpose.
Sorry, are you quoting from the regulations which say that we have to have an affidavit unless that would serve no purpose?
Yes, indeed. Well, I mean, no, that's my submission, but I'm saying that the way I read the regulation, that's 6. If Chairperson can go to 6, it says the Commissioner may direct any person to submit an affidavit or a firm declaration or to produce any document in his or her possession or under his or her control. And then there is comma, and after the comma it says, or to appear before the Commission to give evidence. So an affidavit is also one of the mechanisms available to the Commission to obtain evidence from a person, but then there should be a reason why the Commission opts for the person to appear to give evidence personally and orally in lieu of an affidavit. And we say, by virtue of the cooperation that Mr. Mapakela has provided to the Commission all along, there should have been no reason for him then to have to be subjected to the to the latter, which is to appear and to give evidence orally. But he has nevertheless opted to provide and cooperate with the Commission, provide an affidavit, unless if the Commission is not satisfied with the affidavit, and if the Commission is not satisfied with the affidavit, Mr. Mapakela will be entitled to reasons why the Commission is not satisfied with this affidavit. But also, we have also taken note of the directive that was sent to Mr. Mapakela was not one that was akin to a commission that has appreciated the assistance that is provided to it, because it ends by saying that he should be warned that failure to cooperate with the Commission is a criminal offense. So that was also something that, in our view, was contrary to all the commendations that the Commission has given to Mr. Mapakela, and thanking him for his cooperation, at some point saying that we will not bother you any further, an indication that it was satisfied with what he has done. But as an officer of the court, he has nevertheless continued to cooperate and has filed an affidavit with the Commission, which then we submit that should be sufficient in order to enable the Commission to take matters that it has raised further, either with other people or in its own report. Then of course it can express its own view. It is entitled to express whatever view it wants to express in its report about the issues that he has clarified in the affidavit. So it was for that reason that in his affidavit, or both affidavits that he has filed with the Commission, The first one, he specifically stated, if I can go to his affidavit, the first affidavit, paragraph 3, where he says that if we read from the 7th line, where he says, I've adequately addressed all matters raised in the directive in this affidavit, and I see no need for me to be subjected to any form of oral examination by the Commission on 22 October 2018 or any other day. As a result, I've employed the services of senior counsel to be in attendance with me on the said date to make the necessary submissions on my behalf. In that regard, and my rights are fully reserved. So all what he's saying here is that I've addressed those matters and I have nothing to add on them. And of course, if the Commission, from reading the affidavits that he has submitted to the Commission, require further clarity, then the Commission can always then engage him in writing, as it has always done. And I understand that the Commission does not operate strictly within the confines of formalism, as I've heard previously with this witness who has just left, that he was also requested to provide certain things in writing. So that is really then how the Commission operates. And it's not like Mr. Mapakela is closing the door to say that I'm not going to engage with you, but he's simply saying that on the basis of reasonableness, then he finds it not to be at this stage necessary for him to be held before the Commission and to provide evidence in writing, evidence orally which he has already provided in writing. So we'll request the Commission to accept the 2 affidavits which Mr. Mapakela has submitted, albeit not being part of the directive of 5 October. So it will be our application to the Commission that the Commission should accept those 2 affidavits and to take those affidavits into consideration when preparing its report and dealing with matters which it wanted clarity from him, and excuse him from having to provide evidence orally, as I've referred to 11.6, which gives the Commission a discretion to allow a person to provide an affidavit or to appear. So I'm simply asking the Commission to dispense with the requirement of him having to provide evidence orally. Insofar as the requirement for him to attend, he has complied with it because he's here, but was simply requesting that he be excused from the necessity of him providing evidence orally. And those will be our submission, and that will be our application. Thank you.
Thank you. Let me just say that there have been occasions early on in this commission where I have written to Mr. Mapakela to get clarity on fairly narrow issues, and he's responded, and I've written back to say thank you. I've noticed in the affidavit that there's statements, and you've said the same over here, that he has cooperated with the Commission. He suggested there that at all times the fact that I reply to him courteously suggests that I accept what he says. I don't think you should mistake courtesy for acceptance.
Indeed, yes.
There's a long letter that was written that didn't deserve a courteous reply, but it received a courteous reply nonetheless. So please don't mistake courtesy for acceptance.
Yes, indeed.
The second thing is, you're quite correct, the regulations give the Commission a decision. I don't read the regulations as suggesting that there is an obligation first to ask for an affidavit, and only if the affidavit is unsatisfactory to call the witness. It gives a discretion to a Commission to choose whichever route it considers most convenient and best. And I've noted Mr. Mapakela's view that we should accept that his affidavit is the end of the matter. I regret to say that that's not the case. He was given a directive to appear because the Commission considered that was the most convenient way to deal with a number of matters. Subsequent to that, he submitted the affidavit you refer to, in which he said, look, that should be enough. Well, thank you, we've considered that, but we don't think it's enough. So if you don't mind, we'd like him to now give evidence.
Yes, I mean, I've made an application to the Commission. So must we understand that to be the ruling of the Commission?
That is the ruling of the Commission, that we'd like to hear his evidence orally.
My instruction is that if that is a ruling that obliges him to provide evidence orally, notwithstanding the affidavits that he has filed, where he has dealt with the matters raised by the Commission, he would like to exercise his right then to challenge that ruling in court.
Well, he's got every right to challenge it in court, but meanwhile, can we carry on and hear the evidence?
No, what you like to do
Yes.
is to challenge this ruling, because if he is to participate, notwithstanding that he does not agree with the ruling, is to defeat the very purpose of going to court. So what he's saying is that he would like to challenge that the Commission is not a court of law. It is performing quasi-judicial function of some sort, and its rulings and how it conducts itself is subject to the court process. If a person aggrieved by its ruling wants to challenge it in court, and it would be grossly unfair for him then to Mr. Mapakela that he is to be prevented of exercising his Section 34 right, the right of access to court. So he would like to exercise his constitutional right, Section 34, to access the court and challenge this ruling that, in our submission, it is grossly unfair to him. And we have not been provided with any reasons as to why Mr. Mapakela is required to provide evidence orally. And we have also noted that even the requirements of Section 6 of the Commissions Act have not been complied with. But those are matters that Mr. Mapakela will deal with in his application to court. So Mr. Mapakela would like to state categorically to this Commission that is aggrieved by the ruling, and he would like to take it to court, and he should be given that constitutional right which should be vested on every citizen.
What you haven't mentioned before Section 6 of the Commissions Act, you said that it's irregular for him to be, that it hasn't been complied with. In what respect do you say that it's irregular to direct him to appear?
No, I've said Mr. Mapakela is the officer of the court, has elected to cooperate with this commission, and has also given an affidavit, albeit not entirely dependent on the directive which was issued. But I'm saying that what we are now confronted with, that Mr. Mapakela should be obliged to answer questions despite him wanting to go to court, is also grossly then unprocedural, given the fact that Section 6 of the Commissions Act has not been complied with. I can take the liberty to read it to the Commission.
Yes.
But it's not a matter that I'm requiring the Commission to make a ruling on. I'm just saying that it's one of the matters that we'll converse in court.
Well, if you say it hasn't...
Section 6
Sorry.
says, offenses by witnesses. Any person summoned to attend and give evidence or to produce any book, document or object before a commission who, without sufficient cause, and in brackets it says the onus of proof whereof shall rest upon him, close quote, fails to attend at the time and place specified in the summons, or to remain in attendance until the conclusion of the inquiry or until he is excused by the chairman of the commission from further attendance, or having attended refuses to be sworn or to make affirmation as a witness after he has been required by the chairman of the commission or to do so, or having been sworn or having made affirmation, fails to answer fully and satisfactorily any question lawfully put to him, or fails to produce any book, document, or object in his possession or custody or under his control, which he has been summoned to produce, shall be guilty of an offense and liable on conviction to a fine not exceeding £50 or to imprisonment to a period not exceeding 6 months or to both such fine and imprisonment. So what Mr. Mapakela sought to do here when I was making submissions was to demonstrate to this commission that he has provided sufficient cause, in which then we have not been provided with reasons why his submissions do not constitute good cause. But Section 3, which deals with how a person is to be summoned before the commission, it states that that is 3 sub 2. A summons for the attendance of a witness or for the production of any book, document, or object before a commission shall be signed and issued by the secretary of the commission in a form prescribed by the chairman of the commission and shall be served in the same manner as a summons for the attendance of a witness at a criminal trial in a superior court at the place where the attendance or production is to take place. So the directive that was issued is not a summons as contemplated in Section 3, but it was a directive that was issued in terms of Regulation 11.6. And the regulations which were promulgated by the President do not at all provide as an offense the steps or the posture that has been taken by Mr. Mapakela, which is to provide an affidavit, and if the commission is sort of satisfied with the affidavit, to compel him to provide evidence. But those are matters that we will deal with at an appropriate time in court, because a ruling has already been made. So I'm really then arguing ex post facto the ruling, which then really then does not take the matter any further.
I understand, but you raised an issue after the ruling had been made, and I thought we should just clarify that so that you can have a chance to be heard on that. But if you don't wish that, you don't have to have it. This
Indeed.
commission doesn't compel anybody. The directive, whatever the Commissions Act says, the directive was issued under the regulations. I haven't heard it said it doesn't comply with the regulations. The regulations go on to provide that it's an offence not to comply with the directive of the Commission. So I don't think the Commissions Act comes into it at all. The regulations don't say that the Commission may only ask for oral evidence if it is not available on affidavit, as we've said. So I'm not going to change the ruling. The ruling of the Commission is that he should give oral evidence, because as far as the Commission is concerned, it is the most convenient way to deal with it, rather than going backwards and forwards with correspondence. And we would like to get on with it. If you're asking for a postponement of this in order to approach a court, I regret that you're not going to be allowed that. And we'll take a short break for you to consult with your client. And then, if you don't mind, we'd like your client to assist us by getting on with the matter. I must say I fail to understand why an admitted attorney, as you rightly say, should not be willing to give evidence before a commission. And I'd like to accept your invitation that you issued, which was that he has and will continue to cooperate with the commission, and the cooperation we require at the moment is that he gives evidence.
Well, as I understand,
We'll adjourn for a few minutes.
I just want to, based on what you've said, Chair, that I do not understand Section 3 right with Section 6 of the Commissions Act, and as well as the regulations, to empower the Commission to force him to testify orally, even if he has made his submissions clear. I understand Section 3, right with Section 6, to say that without good cause, if a person fails to do so, they commits an offense. The commission is not the one who is going to decide that he's committed an offense. The commission is not a court of law. The commission becomes a complainant, and the commission will then refer the matter to the relevant authority to deal with it. That is how I understand the law. I don't understand the commission to be a judge and a complainant at the same time. So all I'm saying is that the commission does not have the power to force him to testify when he has made his point very clear, that he is not going to testify on the basis that he has provided through my submissions.
You're perfectly correct that I can't force him. There are no cells here. I can't call in the police. I can't lock him up. Perfectly correct. I've said to him my ruling is that he should continue. You're quite right that it's a matter for prosecution. If he doesn't continue, and you can argue what you wish at the prosecution if there is one.
That is what he wants to do.
Can you allow me to finish? But I'm saying to you that the ruling of this commission is that he should give evidence orally, and if he chooses not to do so, then he will face the prospect of a prosecution. But you're quite right, I can't tie him down to the desk there and interrogate him in some way.
Indeed, so then that is what he's saying, that he will await the complaint by the commission to the prosecution, but what he's saying is that he's going to take the ruling on judicial review that has been made by the commission.
He must do that if he wishes. If he wishes to wait for a prosecution, then he must do so. If we're going to take a break, we'll see when we come back whether Mr. Mapakela is going to give evidence according to the ruling, and that's the way we'll continue.
I've taken instructions already before this proceeding started.
We would
Unless if he must then take them again, whether he wants to reconsider, then I can do that.
No, well, you can do as you wish. We're going to break for a little while.
So he's telling me that he's not reconsidering, and so then he's actually then standing by what
That's fine,
I've
but
submitted.
we'll deal with it afterwards. We're going to break for a while, if you don't mind. Thank you.
Indeed. The instruction that I've communicated to the Commission.
Okay, we'll get on with the next witness, but let me make it clear that your client is not excused from giving evidence, and if he chooses not to do so, well, then he must do so at the risk of facing prosecution.
Yes, he's aware of those consequences.
Yes, and also, by the way, you must accept then that when we weigh the evidence, that we will have to draw whatever inferences we think are appropriate on the evidence we have, and he's chosen not to fill in the parts that we still wish to answer.
Precisely, that is entirely upon the Commission to do so.
Yes, Mr. Stein.
Lebelo here. Judge, I had asked through his attorney for him to be at 11.
Who is attorney?
Is his attorney here?
I think the secretary's going to...
Is someone attending to Mr. Seo? Do you want to just pop out and see if there's anyone here?
I think our secretary's popped out.
Oh, thank you.
To me, she's a role model of a practitioner. Good temperament, very knowledgeable. It's a really, I place a lot of...
It was crude like it was. There was no beach time, civil beach time.
Socially friendly with her. You shouldn't have time for a social life, should you?
Yes, good morning. Are you representing Mr. Lebelo?
Indeed so, Judge.
I don't think we have met. I'm not sure what your name is.
My name is Tabiso Machaba.
Yes, Mr. Machaba. Is there something you want to say before your client gives evidence?
We have had a consultation, extensive consultations with Mr. Lebelo. We were able to agree as the legal team together with Mr. Lebelo that in the interest of time and in augmentation of the evidence that he had presented on the 27th of September, that an affidavit be submitted in order to deal fully with whatever evidence that he had presented. And there are three reasons, Judge, that informed the decision. First was the consideration of time. We have read the transcript of what happened on the 27th and the 28th, and we were mindful of the engagement and examination of Mr. Lebelo's evidence, which took some time, and in the process did not allow him the opportunity needed to refer to various documents in the files that he presented to the Commission. So that was the main consideration, that in order to get that into the Commission, the affidavit will be okay. Secondly was the nature of examination, because Mr. Lebelo is not legally trained. And at some stage it took a turn that he expressed on the 28th that he was dissatisfied with the manner in which the examination went. And the advice that we gave was that in order to avoid that, perhaps, or even to limit that, perhaps the affidavit, if it's acceptable, it will go through. And then if there are any further questions that arise from the affidavit, then you may then field those questions. So what we have done, Judge, is that we had prepared an affidavit that was emailed to the evidence leader yesterday. And we were then informed on that basis that we should prepare ourselves to be here around 11 o'clock. And we were here. The affidavit we submitted, and we request that it be accepted in terms of the regulations as an augmentation of the evidence that Mr. Lebelo has presented to the Commission.
Thank you. Well, the affidavit, as you say, was not asked for, but you're perfectly entitled to file the affidavit if you wish. I think it came last night, did it? What time? Anyway, it's on. Anyway, it came yesterday evening sometime, I think. And we've seen the affidavit. As I understand it,
It's going to fall.
It's going to fall even more there. And as I understand it, your client is still willing to answer questions that arise from the affidavit. Is that correct?
That's correct, Judge. We have explained the process, and he is comfortable to proceed.
Thank you. I just want to correct one thing on the affidavit, if you don't mind. Do you have it in front of you?
Yes, Judge, we do. The affidavit?
Yes.
Okay, yes, we do.
If you turn to page 42. Do you have it?
Yes, we do.
The top paragraph, and perhaps you just put your finger on page 65 as well, which is the annexure referred to in that paragraph. You'll see he says, after deliberations with Judge Nugent, that there was a lot of information which was not before the Commission and which I know of, albeit in my memory. To this end, it was agreed that I approach SARS attorneys who are responsible for the disciplinary hearings to provide us with the original files used during the 2015 hearings. I attach here to a copy of an email dated the 2nd of August. If you can just turn to that email of the 2nd of August, which is at page 65. You'll find nothing there, I don't think, that says that it was agreed that he would go to his attorneys. He said he wished to go to his attorneys. What he chooses to do is his own business. Off he went to the attorneys. But as I read this affidavit and Mr. Mapakela's as well, it seems to me that they're trying to shift it onto me to have said that I want these documents. Let me make it quite clear that it is not correct, nor did I suggest so in page 65. It was up to Mr. Lebelo to decide what he wanted to do, and if that's what he wanted to do, he was told, go ahead and do it. There was no agreement that he would go to his attorney, and it is not borne out by that. Be that as it may, I just wanted to make that clear. Mr. Lebelo, good morning to you. Do you affirm that the evidence you give will be the truth, the whole truth, and nothing but the truth? If so, will you say, I do? Sorry, I didn't hear you.
I do.
There are just two documents I'd like to deal with at the outset. You will recall at the last occasion there was some difficulty with an opinion that had been or a memorandum that had been written by Mr. Brassey. Do you recall that?
Yes.
And you said you had not seen that, correct?
Yes, at the time I said I did not see it.
And but there was a suggestion that Advocate Steinberg had held it back in some way from you. Let me just get this clear. I think you're aware from our discussion that the email address used by the Commission is accessible only to me and the Secretary. Do you know that?
Yes.
And so emails sent by you don't necessarily get to Advocate Steinberg unless I pass them on to her. On this occasion, the email that you had sent was not passed on to her. So she was not aware of that email, number one. Number two, I had given her that memorandum that had been sent to the Commission by Mr. Brassey, passed it on to her, and she was not aware that it was not in your possession. You accept that? She was not aware that it was not in your possession. I had passed it on to her.
Okay.
She had assumed, as I had assumed as well, that a memorandum that had been given by Council to SARS would be known to you and to SARS. And it came as rather a surprise that it wasn't. So that's the first thing I just want to clear up. The second thing is you have now been given the opinion by Advocate Trengrove, is that right?
Yes.
And you've read that opinion?
Yes.
And that opinion on the heading says, Opinion for the Commissioner of SARS on the Sikakani report, correct?
Yes.
And that was given on the 1st of September 2015, correct?
Yes.
So let me just find my copy here. And you'll see that in that opinion, do you have it in front of you?
Yes.
The opinion given was that there was nothing in the National Intelligence Service.
Judge, which page?
Let me find it. Paragraph 49, page 24. Sorry. You have it?
Yes.
You'll see that comes after an analysis of the National Strategic Intelligence Act. And the advocates point out there that the key matter of the Intelligence Act is the protection and advancement of national security. It is clear that the purpose for which SARS collects information is not to protect or advance national security, but to administer and enforce tax legislation. You see that?
Yes.
So it says the National Services Intelligence, National Service, National Strategic
Strategic Intelligence Act.
What is it called?
National Strategic Intelligence
The
Act.
National Strategic Intelligence Act does not prohibit SARS from collecting information. You see that?
Yes.
It goes on to say, if you go to
25.
at paragraph 50, on that basis, the information collected and evaluated by SARS for the purpose of administering and enforcing tax legislation does not constitute intelligence as defined in the NSIA, nor does it constitute departmental. Based on the purpose and the matter of the NSIA, we are of the view that SARS's activities in collecting information for the purpose of administering and enforcing tax legislation are not governed by the NSIA, nor does the NSIA apply to them. For that reason, SARS activities in this regard would not contravene the provisions of the NSIA. You see that?
Yes.
They also in here list the kind of activities that the Revenue Service may engage in. Do you have it offhand?
Sorry, what are you looking for, Judge?
There's one about they can go around driving cars and watching people and so forth. Yes. The list, if you look at paragraph 41, the list of special investigative methods provided to us to consider includes the following activities. And on 542, the general rule is that SARS may only employ methods authorized by the underlying statutory authority. It means that both the method and the purpose for which it is used must be underpinned by statutory authority. The authority may be express or implied. SARS has all the powers expressly conferred in it, and all such powers as are necessary or ancillary to its express powers. An important consideration in each case is also whether its investigation intrudes upon the rights of others, and particularly their right to privacy. A court would be less likely to recognize an implied statutory power if it intrudes upon the rights of others. The implications for SARS' list of special investigative measures are along the following lines. 1. SARS may keep people under surveillance in the public domain, but not in private. SARS may follow a person or vehicle in the public domain, but not in private. SARS may probably place an electronic tracking device on property to trace its movements. It may, however, not place an electronic tracking device on a vehicle to follow the movements of its driver because it impinges on his or her privacy. SARS may watch a person or property such as business premises, residences, containers, etc., but only in the public domain. SARS may take photographs or videos of people or property in the public domain, but not in private. SARS may not listen to or record private conversations unless a SARS official is a party to the conversation. SARS may not electronically record third-party conversations by using listening devices. SARS may record conversations between SARS officials and third parties. SARS may accept information from informers on the basis that their identities will not be revealed. SARS may accept information from a person even if it knows that the information was unlawfully obtained. It may, however, not accept stolen property. SARS may not use other abusive practices or threats to secure any income. So you'll see that he lists there the activities that SARS may get up to, and those include what would ordinarily be called surveillance, provided it is within limits. You see that? That was his opinion.
Yes.
Given to the Commissioner on the 1st of September 2015. So I think that now we've now cleared up the two documents that were contentious. The one is you've seen the Brassey memorandum that was written on the eve of the disciplinary hearings, and we've been through that, you know its contents, and we've seen that Advocate Trengrove gave an opinion in September following upon looking at the Sikakani report, and he said surveillance activities are permitted provided you keep within certain bounds. Is that okay? Can we carry on from there?
I suppose just on my side, Judge, I think at the conclusion of the last occasion that Mr. Lebelo appeared before the commission, he suggested that he had heard during the lunchtime or so, after he had been excused from testifying until he came back, I think on the 27th, he suggested that he had read these two opinions, both the Bressy opinion and the Trengrove opinions that you've made reference to, and suggested that counsel in her questions may have misrepresented the actual contents of those opinions. I just want to understand whether Mr. Lebelo still stands by that assertion, and if he does, what's the basis of that submission?
And good morning to the Commission and to the Judge, and thank you for taking me through the two opinions. I think the only points I want to make on the two opinions, one is that the first one, all I was raising was that this document were not put before me.
Sorry? All you were raising? I can't hear you so well.
Was that is it better now?
Sorry, I couldn't hear you there.
Okay. I was saying all I was raising is that the two documents which I was expected to respond were not put before me. And in reading them in the short period that I read, it did not imply what, when I was questioned, seemed to have implied. And there are two things. One is that the opinion of Advocate Drengov was completely saying that the unit was not unlawful. And when I read it at the time that I read, of course it's written by senior counsel, it specified incidents that will be acceptable and incident that was not acceptable. And for me it meant that it depends on incident that happened. But it was saying SARS can do this, it can do that, SARS can do this, it can do that. So for me it was not saying that that cannot happen. The second one was that, and that's why with now that I've received the document, the second one, firstly, was not a legal opinion. The second one was a progress report. So when I received the opinion, when I received the document, I then discovered exactly what happened in that meeting. So the impression that was created was an opinion, and the second impression was that Advocate Brasey wanted to remove certain charges, and I instructed him, or I kind of insisted on him to do that. So that is also not true from that document in my reading.
Sorry, you say it wasn't, it's what Advocate Brasey says is not true.
No, I'm saying it not, from my reading of the document, it was not entirely true.
Yeah.
That I said, I pushed there. And if I were to give clarity on that one, I then discovered that was a report from a meeting we held between Advocate Brasey's team, the attorneys that were briefing him, and myself, where he was giving us a brief because they were about to do the charges. The question there was about the three charges, which he was saying they can't stand together. And I was advised, obviously, because we were sitting in a meeting. It was not like I was sent something and I responded. We were sitting in a meeting. And after discussions and with the attorney advising was that because they can't stand on their own, you can put them together. And Advocate Brasey was happy with putting them together.
Well, the question asked by Mr. Kashla, if we can come back to that first. He said you've suggested that what counsel put to you was not correct. Do you still maintain that, having looked at the documents? And if so, what basis do you say
yes,
it was?
I've said the two bases, Judge. I'm saying the first basis was that the impression that was given to me was that it's a legal opinion. And it was not a legal opinion. The second basis was that Advocate Brasey did not want to continue with the charges about the rogue unit, and I instructed that he must not, as if he didn't want to, and I instructed that was not. And I was explaining that it was not a legal opinion. Secondly, it's not that I instructed him. It was a meeting that we had with him and his team, and it was the outcome of that meeting. So it was not me directing him not to follow on those charges.
Well, let's go back and make sure we've got an answer to the questions. You say the first one is that the extent to which counsel you say misled you, was to call it an opinion when in fact it was a memorandum. Is that the problem?
Yes.
Well, if that's what you're concerned about. The second one is you say, and could I just turn to that memorandum of Mr. Brassey's? I don't think I have it.
If I can read out the portion that's with reference to it.
And you say that she misrepresented to you that it said that you had instructed them that the charges should be proceeded with. And let me read the memorandum. Yesterday we recommended to our client SARS that of the 3 sets of charges currently being pressed against Mr. Pillay, SARS Deputy Commissioner, the charges concerned with the so-called rogue unit should be held in abeyance. Our advice was premised on the fact that the evidence, so far as we've been able to gather it, is far from conclusive on these charges, and that witnesses who might be called to substantiate the case were proving to be uncooperative. In response, our client, represented by Mr. Luther Lebelo, has instructed us that all 3 charges should be pressed together, and we happily submit to such instructions. So he says that you had said, notwithstanding my advice that they should not be proceeded with, you had said proceed with them in any event. That's what he says. Correct?
Yes.
And now that's what counsel put you, that's what he had said. So where is the misrepresentation to you by counsel?
I'm saying that the cross-examination that was put to me was creating an impression that there were charges that Advocate Brazy didn't want to proceed with, and I overruled him. And I'm saying,
that what this says?
Yeah, but I'm saying that it's not. There is a difference between what is written and what happened. I'm saying what happened.
I understand that, but that's what she put to you from the memorandum.
Yes, I'm saying.
You're saying, well, sorry, let's just get this correct. You're saying that what Mr. Brassey said is not correct.
No. I'm saying the context, after I saw the opinion.
Yes.
And at the time that I read it.
Yes.
And when I reconsidered, I remember this was a meeting. It was some kind of a minute, if you like, of saying, we had this meeting, this is a progress report, we raised this with the client. He could have used any language. I'm saying at the time, there was a discussion and the meeting agreed that it will be better if you compress the charges together. It was not me saying it.
Well, I want to just...
But I'm saying, Judge, because I don't want us to really get stuck here. I'm saying that's my view, that the impression that was created was that I stopped the charges. I went back to this opinion. I found that it was a meeting, which meeting all of us agreed that you can compress them together. So it must not be reduced into me. But that's my view. And
I'm still interested in your answer to Mr. Kushler's question. In what respect did counsel misrepresent to you what was contained in this memorandum?
I'm gonna respond it for the last time.
No, you don't have to do it for the last time. Just tell me the answer this time.
I gave the answer.
She put to you what was in the memorandum.
I gave the answer and I'm going to give it again.
No, you're not going to give it again. You're going to listen first to my question, if you don't mind. She put to you what was in the memorandum, correct?
No.
Sorry, she put to you what was in the memorandum. Do you agree or don't you agree?
I'm saying the impression that was created was that he did not want to proceed with the charges and I overruled him. And that was the impression that was created on the cross-examination. And I'm saying that impression was incorrect.
She put to you what was in the memorandum. Is that correct or is that not correct? It is yes or no?
She put that on the memorandum.
Yes.
She proceeded to cross-examine me.
Yes.
And I'm saying the nature of the cross-examination and the impression created by the cross-examination created that impression, which I found that it was incorrect.
Yes.
Because she didn't ask me one question. She asked me a question and she made follow-ups and she made follow-ups. And I'm saying those follow-ups created that impression. And that is my view. If the commission doesn't agree with the view, I think that's fine. Well, but that's my view and those are the two answers that I gave.
See. Okay. Is that okay, Ms. Steinberg?
I would just like you to clarify, Judge. I don't understand a memorandum to be minutes of a meeting.
Well, whatever they are, you put to him, as far as I can remember, and you'll find it on the record, you said that's what the memorandum said, and you put to him what the memorandum says. Whether the memorandum is accurate or not is another matter. I didn't understand you at all. to say, I know more about this than I've heard. You put to him the memorandum. We know what the memorandum says, and we've heard the explanation, which is not that you put anything inaccurate as it was contained in the memorandum. So I think we'll leave it at that, if we may. Is that okay?
So just need just some clarity, Mr. Lebelo. Are you suggesting that counsel suggests, that is Bressy, that the charges should be compressed together? Because what I read out of the memorandum is that in relation to the so-called rogue unit charge, he expressly said it should be held in abeyance. And it sets out that the basis for his suggestion that it be held in abeyance. And then completes this by saying that you then pressed that they should be, you then instructed that they should be pressed together. So the comprehension together is actually on the submission of, on this memorandum, was by yourself, not by Advocate Bressy.
Yeah, but so if you go further and read the memorandum, it also tells a story. It tells a story. If you look at paragraph 5.3, it tells a story of Mr. Johan Dival will come, and all I'm saying, and this is the evidence I'm giving, I'm saying, when I looked at the memorandum and I considered what happened, is that there was a meeting where we were given feedback. I was with my attorney, and maybe the judge will know that when you're sitting with counsel, you're sitting with an attorney, sitting together, we're planning a case. We talk as a team. It's not like there was an email sent to me and I gave instructions. So that was the discussion that we had, and that was the proposal that was put there. And Advocate Bressy is even saying here that we happily complied. And I can assure you that Advocate Bressy will never be instructed by me to continue with the charge that he doesn't believe he's going to do it, because he's the one who was going to do it. I took advice of the general meeting that was there, and of course, because I'm a client, that becomes the client's advice, and that is how we work as we brief counsel.
Yes, I've seen your explanation. It's also contained in your affidavit, the explanation you've given. Now we've read that. It's fine. We'll deal with that in due course and weigh it up with all the other evidence. May I just clarify one thing as well, and I think it's fair to SARS and to you to do so. As I understand your affidavit, the initial bill you got, account you got, for collecting, I think it was those documents, those 2, 4, 5 files there, was 1 million rand. Is that right? And it was
can I deal with that?
No, just okay. Answer the question. Is that correct? I'm
Yes.
looking at your affidavit.
Yes.
It was first about 1 million rand. Is that right?
Yes.
And then you negotiated it down to 759,000 rand. Is that correct? And that.
Yes.
And you are still in discussion with the attorney as to whether you're willing to pay that amount. Is that correct?
Yes.
Okay. Is there anything further you want to deal with?
No, Judge. No, we accept that Mr. Lebelo has now given a full account of the evidence in these files, in this affidavit.
Well, he's given an account of how he interprets
Of how he interprets it, yes. And we accept, as you've said many times, that on the information given to Mr. Bressy at the time, he drew up a charge sheet and he was willing to prosecute. We accept that.
Yes. Okay, well, I think that's, is there anything further that anyone else wants? I don't think so myself. May I just address your attorney for one moment? And that is, we have the affidavit. We will evaluate. It doesn't mean that everything in here is relevant to our inquiry. We will evaluate it and take account of whatever we think is relevant to the inquiry. We will look at that together with all the other evidence and weigh what is said there with the other evidence that is relevant to the inquiry and reach our conclusions. Is that in order? Is that in order?
Yes, it is.
Thank you.
Judge, Mr. Lebelo would like to address an issue that is contained in the affidavit, and it relates to yesterday's newspaper article about this invoice that we have just spoken about.
Yes, well, I don't know. I don't know
Article,
what was in the newspaper myself. I was told there were some reports, but
Yes.
you say you want to address it.
Yes, Judge, and thanks so much for allowing me. And I must say that is one of those that I want to address because it was very unfortunate. So, in the evidence on Friday, a statement was made that I have spent 759,000 rand to come and clear myself before the commission on my own cost and all that. And it was run all over the papers on Friday and Saturday and Sunday, and it has caused so much damage and pain purely because it is not correct. It has really cast an expression on me very badly. Now let me explain it because it's deep. And I'm leaving the issue about the agreement or the no agreement. My understanding is that I had a conversation with the judge a number of times, and I realized that the evidence that we had was not sufficient to converge between what I thought I had and what the judge had. And in that meeting, and I'm saying this and I'm talking about my own understanding without dragging the judge into it, that I then said the best way is to maybe get the files that existed at the time of the disciplinary, so that I don't say I know this and then the judge said I was told this and whatever. And I left, as per the new policy, I filled up a form to the head of legal, Mrs. Refilo Mukwena. That is how the process works. And as you can see on the form, which is attached here, I make it clear that this is for the purposes of the commission. So I say the short description is that compile a report and full files on the following matter on which you were instructed, and I mention the names of the employees, and I say I'm just looking for that part, and I say this compilation files is for the Commission of Inquiry. And I might not be factual here, but I remember I even said to Mrs. Refilo Mukwena that she must check with the commission before she approves because it's coming from the commission. So at all material times, I understood that I must get this information so that it helps the commission. The files were as per the disciplinary action that took place at the time. So my expectation was that the disciplinary action was stopped 5 days before. There should be files sitting somewhere. Somebody must go and dust them off and give it to the commission. So that was my understanding.
Okay.
And the file went. When I was told by the same firm that the files will be ready on Friday, I wrote an email which is in the affidavit. I said to the judge, thanks that I hope you had a good break. And as per the discussion on that day, the files will be ready on Friday. Can me and you meet so that I can take you through, I can give you the file, either take you through or whichever way. So I gave options there. And this continues to show that I never for a moment had any other aversions, but that is what the commission needed. I met with the judge.
It was what you felt the commission needed.
Yes, I'm continuing on that note.
Let's get that perfectly correct.
At all times.
Don't blame me for spending $1 million.
No. I'm saying at all times.
Yes.
From the conversation, from the forms, from everything else, is that the files were for the commission. I would not have went and filled up a form and asked for SARS information for myself personally. It's against the law. I can't do that. I can only do it on behalf of SARS. When the files came, the judge will remember I met with him twice, take him through the files the first day, and the second time also we met, and I took him through the files. And on the basis of the file, he made a decision that I must come and present at the commission. Probably a few days before I appear before the commission, I received a bill from the same law firm, almost to the amount of R1 million for the files. And I was shocked because all I thought is that if you're about to charge people, it means you've got files with you. And my instructions were clear, just retrieve the files. So I thought people would just go get the files, clean it up, maybe make 2 copies and bring it here. So I didn't even expect it to be so much money. I then wrote a letter back to the law firm and I said, there is something wrong with this invoice for my expectation. The email is in the, I'm not quoting it verbatim, is in the file. I mean, it's in my affidavit. The law firm responded and said, we apologize, we did a mistake, we didn't do quality check. They reduced it from that to 200 to 759. I appeared before the commission. Unfortunately, I had to leave for a family event. When my office was insisting that I must sign it, I said, no. Even though they've reduced it to 759, I still cannot fathom, I cannot comprehend that retrieving files that were ready at the time of the hearing can cost so much money. When I come back from leave, I will then send them a letter again and say, now that you've clarified your quality errors, clarify for me how can files that are supposed to be in a cabinet cost you so much money. When I was on leave, the commission told me that I must appear today. I asked the commission whether there is anything extra. And then I was then presented that I must come and explain this invoice. So I knew that today I'm going to come here to explain the invoice. The important thing about the invoice is that I didn't sign it because I was lodging a complaint. I even said to my colleague that this is one of the invoices that we must even take to the Law Society if you like, but it was said in jest that we need to argue about it. But unfortunately it was there. I still don't know how can an invoice that was in my office and my office was locked ended up in the commission, but I don't want to get into that. The fact is that it get into the commission. I was coming here to respond to it. Unfortunately, on Friday, a statement was made, which statement cast an aspersion on me. But the important principles are that the invoice was brought to me from people who were supposed to just retrieve the files that were existing. It was exorbitant. I questioned it. They reduced it. I was going to question it again until I get to the bottom of the matter. So that invoice is on record. So I thought, let me clarify that because they really, the impression that was created and the noise that was ran on Friday was that I personally did the following things. Now, let me also clarify some little thing that appeared, which I thought the acting commissioner might also been confused in the fact where he said, I was given legal representation. The legal representation that is here is not Mashiane. The other one is Mashiane. And the reason why we had to go to Mashiane Mutli for the files is that they were the attorneys that were instructed to work. So you can't go to any other attorney. It's only them who can help. Now, one of the things that the acting commissioner raised here was that I was given legal representation. Indeed, it happened. So one day in our conversation between me and him, he told me that some other senior person has requested for legal representation to appear before the commission. And I told him that I thought about it, but I don't think I need it. And he said, no, I think you need it. You must send an email to Mr. Makungu Mtebule and ask for a legal representation, which I did, is in the affidavit. And then they responded and said they're going to give me legal representation as one of the things that EXCO has given, that if an employee needed legal representation, they must ask. I never thought I needed it until I had a conversation. Now, the problem with that is that they only came to me 2 days before I appeared before the commission the last time. So I had two options. The one option is that I asked the commission to postpone, which I didn't think it will work. But the second option is that if you are told that, okay, get lawyers 2 days before you appear, what will happen is that by the time you meet them, if you sort a date and stuff like that, you'll be appearing to the commission. So I called my colleague Aliwala. I said, look, given that it's only 2 days, 2 full days before this, I don't think it will be prudent for me to use the lawyers. Otherwise, I'll pay them for only consultation. The files are many. And on the basis of that, let me go there without the legal representation. And I came before the legal representation. And when I was here, I then said to the commission that given what happened, I think I'll need legal representation. I went back. I sent an email to Aliwali, CC, the acting commissioner, and I said, look, you know I came back from the commission. Now I think I'll need the legal representation. He told me that, no, that's fine. They'll use the insurance that SARS has with lawyers. And I can choose any lawyer that I want. I even emphasized to him that please give me the same set of lawyers that you can give. And I was told that you can get an attorney and a counsel. And I was given an attorney and a counsel. So the lawyers that are personally representing me here are the lawyers that a decision was made by EXCO and acting commissioner that you can get if you want the legal representation. The one of Mr. Mapagela, the only reason why the files have to be sought from them is purely because they ran the thing. So they really, the impression that was created in the public, there in the media, is not correct. My intention, and I'm saying it here, that we're going to go to, and I'm using the word loosely, we're going to go to war about that invoice because I still need to get answers as to how does files that are expected to be sitting somewhere in a cabinet tend to cost us so much money. And I'm
There they
making the
are.
last
Those are the files you presented.
Yes.
5 files.
Yes.
Well, that's about 200,000 rand a file, I suppose. Yes.
Yeah, I don't know. The other thing, Judge, that I want to just conclude on, and I didn't include it.
Let me interrupt you and say that the fact that you have got counsel or attorneys with you today is not an issue. The Commissioner has said anyone who wanted to have an attorney or counsel with him or her giving evidence perfectly in order, so that's not an issue at all. I don't think that there's anyone suggesting there's anything wrong with that.
Okay, I'm just closing that. I'll be submitting. It's not part of the affidavit, but I'll be submitting 1 or 2 emails that will answer 2 things that happened in the previous one. The first one is about 2-3 emails that we sent in 2016, complaining to the office of the commissioner at the time, Commissioner Moyane, about the issue of the invoices. You'll remember there was a question about why do you pay invoices that are not within your purview. So I discovered now that there are a number of emails where I sent to him and said, but this is a problem. There are emails about a lot of things that we don't know, and this is a problem. And then I'm sure there are about 2-3 emails where we complained as far as 2016. And at some email, he responded to us and said, guys, just pay. So I wanted to answer that other aspect. The other emails that are here that we'll also submit is to also demonstrate that as early as 2016 and around those times, we have sent emails in particular, but they are only for Mashiane, just to demonstrate that the battle about fighting for invoice, we've been having that battle since 2016. My team knows that when an invoice lands, they must go through an invoice. If they are not happy, they must question that. You'll see there that there are areas where the law firm, in particular Mashiane, had to cut some of the cost, they have to reduce some of the cost, and have to give away some of the cost on the basis of the battle that we put to them. So I'm doing this so that it shouldn't create an impression that when things happen in our office, we don't contest them. But that's all I wanted to clear, Judge. Thank you so much.
Okay.
Judge,
Thank you.
I simply want to give the basis of the evidence that was put to Mr. King on Friday. There are 3 documents. The first is merely a transcript of Mr. Lebelo's evidence. The reason that the impression was created that the files were prepared for Mr. Lebelo's benefit rather than SARS is because on repeated occasions in his testimony, Mr. Lebelo said that he had come to clear his name. And I want to read one extract. I quote Mr. Lebelo, "The reason why I'm here, the major reason why I'm here, is that over a couple of years, and I can say roughly 4 years, a particular narrative has been created, and if you like, ratified, which suggests that either myself, I participated in what is known as a purge, some of my colleagues whom I worked with for many years, which I had a good relationship with, where I was used in that place to purge my colleagues." And it goes on, I was quoted as a Moyane hitman, and if I don't come and tell the truth and the story that I know, the stigma of being a suspension hit and being a purger will continue the rest of my life. And there are many, many examples where Mr. Lebelo said he'd come to clear his name, and that was the basis, one basis, of why the advocates of this commission had understood that these files were less about SARS and more about Mr. Lebelo.
Yes.
Now, when it comes to the instruction to Mr. Mapakela,
Just a minute, Ms. Steinberg. You know, I don't think we should enter into arguments at this stage. I accept that it was on the evidence. I'm well aware of that, the evidence you've read. We will weigh up what he now says against the evidence that was given, and we'll make a decision. But I don't want to enter into argument at this stage, if you don't mind.
I need to be clear. When there is an accusation that there was a misrepresentation from counsel, I need to clear that up. I have to have that on the record.
Well, you've put it on the record, I understand. What else is there? We've just discussed where the misrepresentations are alleged to have occurred. He's told us we've dealt with it.
I'd also like to put on the record that when one looks at the legal instruction Mr. Lebelo gave to Mr. Mapakela, it's not merely for full files. it's also for a report.
Yes.
If one looks carefully at the invoice that goes on for pages that comes to 759 million rand, collating information is merely one aspect of it. What Mr. Mapakela is doing according to his invoice is he is making a case and he is writing submissions for Mr. Lebelo to come to this commission. He's asked to link evidence, to explore evidence, to investigate evidence, and to put it into a report. And there are repeated meetings with Mr. Lebelo. So it's simply inaccurate to say that all Mr. Mapakela was asked to do was to put together these files. That's not the instruction he was given, and nor is it what his invoice reflects.
Well, let's deal with the two separately. You recall that in the evidence, you had said on a number of occasions, on the last occasion, that you were here to clear your name. Isn't that correct? Is it not on the evidence? Well, just a minute. You've heard the evidence read to you. You don't have a transcript of the evidence? Do you have a transcript in front of you?
No.
Well, can you give him that section of the evidence, please?
Okay, I'm advised that it is there.
Okay, so that's the point she's making. You accept that you did say you're here to clear your name?
Yes.
Yes. Okay.
But that is not... That
Is it not correct?
No. Let me explain that part.
Okay.
And unfortunately, Advocate Stenberg was not part of the meetings that we had between myself and the judge.
And, between yourself and?
Between yourself.
What's that got to do with that evidence?
No, I'm explaining it.
No, what has it got to do with that evidence?
I'm saying that the conversation about my purpose of coming here, I had that conversation with you.
Well, our conversation is not in the evidence. She's talking
I'm not saying that, Judge. I'm saying...
Can you let me finish as well, Mr. Lebelo? Then we'll understand each other. That evidence has got nothing to do with any conversations with me. It's got to do with what you said your purpose was. And that's what she's asking you about. You said there, I'm here to clear my name. And she says...
Let me clarify that. In the affidavit, I've attached an email sent to the judge explaining my purpose of being here. Is in the affidavit. That is number one. Number two is that on the 28th, the judge asked me the same question here and said, Mr. Lebelo, you said you are coming here to clear your name. I responded here and said, no, Judge, it's not correct. I'm not coming here to declare to clear my name. It's on record that I said on the 28th. If you look at my submission when I started, I explained my role, I explained my purpose. The issue about clearing my name it comes together. I was saying that colleagues came to the hearing, gave evidence, which evidence included the fact that they were patched. And I was saying that after hearing that, I want to come and give an alternative view to what the colleague said. As the head of ER, and consequentially, I've been alleged to be a hitman who have suspended people. I even said to the judge, in the evidence it will show that I was not even involved in the suspension. But I think the evidence that has been put here is that all I'm saying is that I came here, I've never had in my head the impression that I'm coming here solely to clear my name. I always understood that I'm coming here to share the information that was in my knowledge at the time of this activities happening. In the affidavit is also explained better in the introduction about that part. Interpretations can be made, but I want to emphasize that when I started here on the 27th, my opening explained why I'm here. The judge asked me on the 28th, and I corrected, and I said, no, I'm not here for my personal whatever, I'm here to share.
Well, there's the evidence. We've heard your explanation.
Yes.
We'll weigh it up in due course.
Thank you, Judge.
The second issue you raised...
The second issue, Judge.
Well, let's just clear up what the second issue is, if I may, and then we can be quite clear. You see, it's one thing that one would like to have asked Mr. Mapakela about, but he prefers not to be here. And that is, if you look at this, if you look at the, I think that's the point, if you look at this invoice, you'll find, for example, where's the invoice? Do you have that invoice? See, under 2nd of August, working on notes and submissions to be made by Mr. Lebelo before the Commission. Attend to prepare for the presentation to be made to Luther in preparing him for the appearance at the SARS Commission. Dealing with the suspension of Richer, linking Richer to the unit, linking Richer to the recruitment of van Rensburg, linking Richer to Project Sunday evenings. You see what she's talking about is there you are being asked to make an investigation and prepare a case, as it were, against the people. Drafting submissions and notes for Mr. Lebelo in respect of Richer. Compilation of the file in respect of Ravelli. Discussion with Mr. Lebelo with regard to the need to hand over the file. Discussion with Mr. Lebelo and acquired further clarity seeking questions by the Honourable Judge Nugent. Well, I certainly didn't oppose questions to him. So we go on, and then if we can go to the letter, you'll recall that Mr. Mapakela then wrote a very long letter to you. Remember that letter on the 22nd of August? Do you have that letter? The letter by Mr. Mapakela to you on the 22nd of August. Very long letter. And that's the one that he sent to you, but he copied to me. Remember that letter? And he copied it to me. I think his explanation for some of it, he says that he took the opportunity unilaterally, he thought, to advise me on how to conduct the inquiry and not to be biased. Remember that one? He said it's like collegiality, he said, thought he better advise me. And in that letter, as you see, there is a whole analysis of documents try to establish a case against these various people. Do you see that? So I think that's what counsel is saying. He wasn't merely instructed to collect documents. It seems he was instructed to extract from those documents a case to be made against these people. What do you say to that?
No, and the difficulty with this invoice is that it's in dispute. There are a lot of things that I see here that I don't even know.
Yes.
But I think the important thing is the page 9 of the affidavit that talks to the instruction. To say, at the time of giving the instruction which I signed, what was the instruction? And that's why I'm disputing, because it must collate with the instruction. Like the letter that he sent to you, I don't know how he wants to charge it here, because I thought it was a letter from him to you.
Him to me?
Yes.
It was addressed to you?
No. If you remember, Judge, if you look at the letter, he says, "Dear Judge," then he goes and tells you a lot of stories. It says
Mr. Luther Lebelo, Group Executive, Dear Sir, 22nd of August. Where does it say, Dear Judge?
If you look at the letter, and we'll look at it, because it must not distract us, but we'll look at the letter. The point I'm making is the instruction that I gave, and maybe this is an instruction that I must read for counsel.
Yeah.
Request to compile a report
Yes.
and files on the following matters to be submitted to the commission.
Yes.
I mentioned the names. So the intention was that you take the files,
Yeah.
and then you compile the report for the benefit, so that you don't give raw files. So you'll say, this file include the following things, and this was the evidence, exactly what I was trying to do last time.
Well, that's an index, but what's the report?
No, not an index. A report of explaining the files. So you must explain and say, this file is for that, this evidence is for that evidence is for that. Is an index that in a form of, that explains the files. So that was the instruction that they were given to do. And then they went, I don't know what was their response. Unfortunately, I hope that they were going to explain it here today. But I don't know what is their response. But all I'm saying is that there are a lot of things that are here which I'm disputing, and I'm going to dispute with them because I don't know how they relate to the instruction that I gave. My instruction was very clear. You compile that thing, you put a short report that helped the commission to understand how the evidence linked to each other. So
how the evidence does what?
Linked with each other.
But why is he explaining why is he trying to make a case?
No.
Explaining how the evidence links to each other. I thought your instruction was collect the documents, put them in a file, and then I want to present them to the judge. Is that the instruction?
Yes.
So why was he going about trying to create a case?
But that's the part he must explain. Well, because that was not the instruction that was given to him.
Do you say your instruction was simply gather the files and present them? And so his invoice, you say, is not true. When he says, I met with Mr. Lebelo and we discussed this and that.
He met with me to take me through.
Take you through the files?
Yes. To explain which file is whatever. So meeting with me is true. The part that is a problem, because obviously he didn't just drop the files, he spoke to me. The part that is a problem is he went and digged, he went and listened to audio, he went and did the following things. My understanding was that the hearing was about to be sitting. You have got a file with evidence you are ready to prosecute, and that is the file that you wanted. We didn't want reconstruction of the files. That was not what I understood.
Well, he certainly gave reconstruction of what he said the file contains.
Which is exactly what he must explain.
And you said it's not your instruction. Do we need to go on?
No.
Thank you very much. Anything more?
Just two things, Judge. Firstly, just a quick one around these invoices. Did I get you right that you said in your evidence earlier that you've had a history of having issues with billing by your attorneys, by these particular attorneys?
Yeah, I only picked up for these attorneys. I don't know whether they are.
No, I'm talking about in relation to these, the ones who compile for you those files.
Came here this morning, yeah.
So this issue you have around billing in relation to them is not an isolated case.
No, and it's not the first time.
Okay. The next point I wanted to is just to understand that I think it's helpful that you will be providing us with an email reflecting instances where you had difficulties around instructions to pay for matters that you could not connect to SARS. Am I understanding you that if you get an instruction from someone at the top, regardless of that instruction being lawful, you would simply just execute it? So if in this instance, if the commissioner wanted advice on a book in relation to him, and you find that book has no relevance at all to his work as a commissioner, and you're required to pay for that, would you consider that part of lawful responsibilities that you've got to execute, that you must pay that invoice?
No, maybe I'll submit the email. So you'll see in the emails that where we went, we'll complain and say two things. These invoices were not part of, and they're not, obviously you're not using the same language, but complaining that we're not part of these invoices, that they're not touching on the issues that affect us, and we're worried about that. Then in one email, then he responded and said, just pay. And once he says pay as the accounting authority, that becomes an instruction that he gives us, that he pays because he paid from the budget. I think the important thing for us is that the struggle of us being expected to pay invoices that are not falling within our purview, and or we're not part of the instructions, we've been raising with the office of the commissioner, and that proof is there, which I'll supply to you.
And you saying he responded in writing that you must pay those invoices that you queried?
Yes.
Did you query the invoice with him which said to the attorneys. I don't know what they charged for that one. 30,000, 20,000?
Which one?
Reading the book.
Have it?
Did you query that with the Commissioner and say, look, why are you instructing an attorney to read a book in order to find what it says about me, the Commissioner?
No,
Did you query that?
no, not, we don't
Sorry.
question that.
Sorry, did you query it? Is the answer yes or no?
Judge, I'll have to check. But what I'm saying is that the context of the query is that you're asking us to pay for a consultation with Mr. Kettler. We're not there, and it doesn't even look like it's an ER matter. And then he responds. So on that specific one, I don't remember whether I said to him about the book and stuff like that.
Well, that invoice was paid
Yes,
and was paid from your cost centre.
yes.
Well, presumably you approve payments from your cost centre. You don't just pay anything.
Yes, and that's why I'm saying in the emails it will show in instances where we complained and we were told that we must pay. That's all I'm saying in the email.
Not complain to the attorney about the amount, complain to the Commissioner about
Yes.
why are we in ER paying for someone to read a book for you.
Yeah.
You say there are emails to that, if
No, not specific, Judge.
not specifically.
All I'm demonstrating is that there were emails where we complained about this pattern, where we were expected to pay for events that were not part or events that are not related to ER. I'm demonstrating that we had that struggle with the Office of the Commissioner, and at some point they send an email that you must pay. And obviously if you send an email that you must pay, you don't ask again. You just say, okay, it means he wants us to pay.
Okay,
It comes from his budget.
You'll
And
provide us with the email.
with the yes.
And in particular, reading a book.
No.
Will you look if there's an email from you saying, please, we don't pay in ER for reading books? And can you please tell us why we must pay for reading a book? You will look and see if there's...
No,
Mr.
I'll
Lebelo, you're not listening. You will look and see if there's an email about that as well.
Yeah.
And you'll give us other emails where you've said to him, we shouldn't be paying this is your personal affairs, and we're not paying for it.
Yeah,
And
not
it
in that
says pay.
specific language, Judge.
Sorry?
But I'm saying not in that specific language, but the judge will
Okay, well,
read.
in
the
whatever
intention.
language it might be, you'll tell us.
Yes.
The cost for reading the book, Judge, was approximately 120,000 before VAT.
120,000 rand?
Yeah.
How long is this book? Is it War and Peace? How long is the book?
I haven't
Do you know?
read the book, no.
Do you know about this book, Mr. Do you know about this book?
Well, Judge, I explained that I was seeing the invoice about the book for the first time.
Yeah, okay.
All I did was to ask,
Yeah.
and I didn't know about the book.
But you would have approved that, you say?
Yes, after I asked whether the work has been
Yes.
done and all.
Well, you'll show us where you...
Just one very quick question. Advocate Steinberg read to you a long invoice, lots of notations. Is your contention that in doing that work, the attorney exceeded his mandate, he wasn't asked to do the work, or he didn't do the work and charged you for it? Which is the two?
I think he did too much more than the instruction asked him to do.
So he exceeded his mandate quite significantly.
Yes.
So where he says here, drafting case for Mr. Lebelo...
I'm advised that I must say possibly.
Say
I'm advised I
possibly.
can't-
Well, I don't think that you can say positively. It's either happens or it didn't happen. So let's just listen now so that we don't get confused. And I think that your attorney shouldn't tell you what evidence to give. He should tell you what you may not answer. That's different. But I don't think he should tell you what evidence to give. Where it says, for example, continuous drafting of the submissions, you say that if he in fact was drafting submissions, that was contrary to his instructions. Is that correct?
Yeah, Judge, I need to go, all I'm saying is I need to go through the invoice. If I were to answer the question is that in my looking of the instructions
Yeah.
and all the other things that have been done, he exceeded
Yes.
the mandate of the instructions. My expectations is that if you are to be charging a person in a week's time, you have got a file that is ready with everything. All I was asking is that go to your cabinet, if you may, get us those files from the cabinet, and it shouldn't listen to tapes and all those things.
Well, will you go through the invoice and mark those which you say he exceeded his instructions for us? Could you do that?
Yeah, when I get to the office, I'll...
No, indeed, not now, obviously.
Yeah, okay.
And then will you also just tell me, when he wrote this long letter analysing the documents and saying it proves this, it proves that. You know, remember that letter we've just been through?
Yes, I will.
When you got that on the 22nd of August, did you go back to Mr. Mapekela and say, what on earth are you doing producing this report, this analysis, and trying to show why the documents proved a case against these people when that was not your instruction? Did you go back to him on that?
I didn't.
Sorry. Did you or not?
No, I spoke to him on the phone.
Did you say to
But
him,
I was.
did you say to him, why are you sending me this report? when
Can
it
I say
wasn't
what I
asked?
said? Because it's difficult to say, did you say this?
Yeah, okay, it's here. But provided I get an
The
answer.
only truth, yes. The only part that I raised with him was that my understanding was to answer whether the opinion is the last one or there's another one.
Yes.
If there's another one, you must give me the next one.
Right.
I was just, and I'm saying this without prejudice, because I was
I'd
talking
say,
to him
well,
on
you
the
can't
phone.
talk without prejudice under oath.
Yeah, I was talking to him on the phone and I said, I thought you went a little bit where you're not supposed to go. But my understanding, and it's another contention, my understanding was that he volunteered to give the judge's views. It was not an instruction. Mine was a simple question of whether the opinion, there is another opinion, if it's there, just send it to the judge. I think he went a little bit more, and it was not an instruction. And if he's going to charge us for that, it's something that I'm going to contest, because I thought he was giving you a free
advice.
Free advice, yeah.
Yeah, well, thank you. Thanks. Ms. Steinberg, I think, my own view is that these are important things, but quite frankly, we're involved in rather more important things. Don't you agree?
I agree.
And that is the running of SARS, this major institution, and what should happen in the future. So thank you very much, Mr. Lebelo, and I hope that you don't have any more consultations.
Thank you.
Thank you.
Judge, we resume at 9 tomorrow morning.
Thank you.
We have a problem. We'll have to take a photo. Yeah. Do you have a cut? Same stand for a moment. But I think he was happy to take questions. Willing to give us a lift. I'm very happy to catch it down there. We'll just take it.
You give us a lift to the station.
Take us to the company.
Oh, my word.
But should
Are you disappointed? No. Norman. Norman.
water.